bon matin. Good morning. I call the meeting to order. Welcome to meeting number 92 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference adopted by the House on June 21, 2023, the committee is continuing its study of Bill C-40, an act to amend the criminal code to make consequential amendments to other acts and to repeal a regulation, miscarriage of justice review. Today's meeting is taking place in a hybrid format. Pursuant to the standing orders, we've got members on Zoom, others are in person, so welcome to everyone, and I believe we have a new member with us, Marilyn Gladue. Welcome to our committee. I believe all members are knowledgeable in the technology and how it works and the interpretation. Just a reminder, please, all comments are to be addressed through the chair. For members in the room, for those on Zoom, we will, with the help of the clerk and the table, watch for hands going up on the screen to ensure that we don't miss anyone. Alors, je tiens à vous souligner que les tests.
I want to point out that the sound tests have been completed.
Today in person is Madame Anna Decker, who is the Avocat Conseil et Directrice Adjointe.
Senior Counsel and Deputy Director, Public Law and Legislative Services Sector.
But we will continue with our study right now, and so therefore we will resume consideration of C-40. And reminder, we are resuming debate on Clause 3. As a reminder, the NDP 1 was withdrawn by unanimous consent on December 14, 2023. And I'm going to ask Mr. Housefather if he please moves Lib-1.
Yes, thank you, Madam Chair. We had some extensive discussions already on this amendment, but the essential purpose of Lib-1 is to allow those most vulnerable people that couldn't have appealed to the Court of Appeals to have the same right as under the current version of the bill they would have had if they had not appealed to the Supreme Court. So essentially it's entirely consistent with the language of the bill, but it just adds a further avenue for those who didn't appeal the original judgment on the same grounds as it allowed for those who didn't appeal their Court of Appeal judgment to the Supreme Court. So I don't think given how much discussion we had about Mr. Garrison's amendment in this one already, I don't think I need to prolong this, but I would recommend, that we support it. Thank you.
Thank you, Mr. Housefather. Mr. Moore?
Thank you, Madam Chair. On this amendment, overall, the concern I have with it is the drafters in their wisdom had a requirement that the decision be appealed. The reason being is that to avail oneself of this process, it should be fairly extraordinary. These are wrongful conviction cases, and while they do happen, they are rare. So by eliminating the requirement as drafted to have appealed, it further lowers the threshold. And we'll get to that when we deal with CPC 1. But the threshold in this process, as we heard from North Carolina, from the United Kingdom, from other jurisdictions that have a commission on wrongful conviction, they have a much higher threshold than what's proposed here. So to eliminate the requirement that one have appealed their decision, it makes a bill that has a level, the floor too low, even lower. Without speaking too much to it in advance, CPC 1 is going to change the threshold from may have occurred, which is the current draft, to a real possibility that a miscarriage of justice has occurred. I think that would be Canadians' expectation, that a miscarriage of justice or wrongful conviction, while Canada has an enviable system, it has its challenges. We had debate at the last meeting around resources for judges, judicial vacancies. There no doubt could be changes to the law. My concern in this, we had a study on the federal government's obligation to victims of crime. And we heard over and over that the process re-victimizes. So they're already a victim, and then they go through the process. And whether that's the judicial process, the parole hearing process, that the victims told us at this committee that the process re-victimizes them. With this process, there is no doubt that there's going to be claims under here that result in new trials. A new trial means that victims have to relive a very painful process that they've already been through. And that is why I think, in light of the fact that this is new to our country, that there's other contemporaries that have dealt with this. We know in the United Kingdom, even with their much higher threshold, that a real possibility that a miscarriage of justice has occurred. Even with that threshold, we heard testimony that there was a literal flood of applications from the pre-existing rules to the new commission. We can expect the same here, and that is why I do not think it's in the interest of victims or our system as a whole to have a threshold that is so low. And this amendment would probably make a possibly bad situation worse. So I'm unable to support it. Thank you.
Thank you very much, Mr. Moore. Mr. Garrison, please.
Thank you very much, Madam Chair. I'm happy to support this amendment. As we all know, that I was trying to accomplish the same thing, but my bill as drafted inadvertently removed a couple of other sentences out of the bill, and that was a drafting error. So I want to go back to the testimony that we heard virtually universally from witnesses, and that is that those who are least likely to have the skills and resources to exhaust appeals are exactly those who need to get considered by this commission. And so if you're looking at people with low levels of education, low levels of economic resources, low levels of information about the justice system, to say that they must have exhausted all their appeals requires them actually to know more about the legal system than most of us do. And so I think that, in fact, is raising the standard way too high. And to respond to Mr. Moore's concern that there'll be a flood of cases, this allows the Commission to look at those applications. It doesn't require them to accept those applications. Now, I also want to go back to testimony we've heard from victims, because the Conservatives often like to cite it. And one of the things that I think, heard universally from victims is they like the right person convicted, and they would not like the wrong person still at large in society. And so part of the, I guess, benefits to society of a miscarriage of justice commission is to make sure that the right people pay the price for their crimes, and that we don't let people, quote unquote, off the hook because we convicted the wrong person. And we've seen some very dramatic examples of that in the past. And so I guess I would say that the importance of this amendment is to make sure that those who most need the benefit of this commission actually get considered by the commission. Thank you.
Thank you, Mr. Garrison. Mr. Caputo, please.
Yes, Madam Chair, may I deviate a little bit? I'd like to ask Mr. Housefather a question about his intent about the sub-amendment. Is that permissible? Or his amendment, sorry.
Sure, you can ask him through me. I don't think
Sure.
I have an issue with that, because I don't believe he has an issue with responding. Go ahead, Mr. Housefather.
Yes.
Oh.
Mr. Housefather is talented, though not telepathic. So my question through you, Madam Chair, is this. Is the intent of this amendment to address historic wrongful convictions? As in, somebody was convicted 20 years ago and they didn't go through the Court of Appeal, the Supreme Court of Canada, or even 15 years ago, 10 years ago, and now they've got an additional leap. Is that your intent, Mr. Housefather?
Yeah, I will only allow you to ask because I think he has no issue in responding
no,
to you.
not at all.
Otherwise, yeah, please go ahead.
Thank you, Madam Chair. So the intent for me is, we heard Mr. Moore cited North Carolina and the UK. In neither is there of those does the Commission have an impediment where they're not allowed to consider cases because of failure to appeal. And so my intention, as was Mr. Garrison's, is to remove that impediment, because it is the most vulnerable defendants that wouldn't have the legal resources or the legal advice to necessarily appeal a case. So if somebody was wrongfully convicted, and we know, and let's say that there's whatever burden of proof we agree to in this bill is met, it shouldn't be that the Commission can't even consider it because they didn't appeal to the Court of Appeal. We've left in the bill an ability, if you appeal to the Court of Appeal and not to the Supreme Court, to have the commission be allowed to consider it. All this does is removes that impediment if they didn't appeal the case to the Court of Appeal. But it's on exactly the same terms and the same grounds as was in the bill to begin with.
Okay. Then I think I understand your point, because as I understand Mr. Housefather's point, I get where he's coming from, and I listened carefully to Mr. Garrison's point and to Mr. Moore's point. I think that the two are actually quite reconcilable. I know that Mr. Garrison spoke somewhat in contradiction to Mr. Moore's point about we want the right people in jail. And I believe Mr. Moore's point is that generally our system does get it right. It gets it right almost always, and that's the whole point, is that when there is a wrongful conviction, it does strike at the heart of the justice system, because it is meant to be rare, and frankly, I think it is rare. So Mr. Moore's point is that in most cases where the right person was convicted, the victim is reliving it, and Mr. Garrison's point is, well, we want to get the right people in jail. So the two are there. The two are reconcilable. My concern is this. A person is convicted by a jury on May 1st, and May 2nd, they're applying on a wrongful conviction. And I don't know if that's your intention, Mr. Housefather, but that is what is permitted by this amendment, and that is my concern. That's why I asked Mr. Housefather, Madam Chair, whether his intent was to say, look at somebody who, maybe didn't have the resources. Now, I think almost everybody would get funding for a meritorious appeal on legal aid. I can't say that with 100% certainty, but that's my impression anecdotally. So I am concerned that somebody who's convicted on May 1 then turns to this legislation on May 2. And if that's not your intent, then I do believe we should be looking at a sub-amendment. And I'm happy to put one forward, but I don't know if again, that's why I asked you for your attention.
Well, you know what? I'll put you on the list.
Put me on the
How's
list.
that?
Thank you.
Mr. Van Popta, please.
Good. Thank you, Madam Chair. I have the same concern as my colleague, Mr. Caputo. I don't think any of us want for this judicial review commission to become an alternative court system. And in response to what Mr. Garrison was saying just a few minutes ago, that those who are least able to hire a competent lawyer, for example, who don't have the resources to do that, they're the ones who are wanting to help. Well, I would say that those are good arguments for improving our traditional trial court system. Maybe better legal aid funding, maybe ensuring that every person who's charged with a serious offense has competent counsel. I think that we're all very interested in our criminal trial system functioning properly, and that it comes to the right decision. But our system is an adversarial system, and the judge's job is to hear the evidence, to give advice, to give direction to the jury, and to allow the jury then to make the decision. It's not the judge's job to. This is not an inquisitorial system. It's an adversarial system, and the Judicial Review Commission will be more inquisitorial. They'll have the resources to do investigations, and that's a good thing. But what we don't want to happen is that it just becomes an alternative or a parallel criminal justice system, that a person who's convicted can decide whether or not they go through the appeal process or go directly to a judicial review. I think that that's what we want to avoid. And so whatever amendments my colleague Mr. Caputo might come up with, I'm certainly interested in hearing that.
Mr. Housefather?
So thank you very much. I mean, I think we all do not want this to simply replace the appeal system, and that is already in the criteria that the commission would use in order to determine whether or not to receive the case. If you look at the criteria, one of the criteria is related to whether or not an appeal could still be made. So I'll pull out the legislation, Madam Chair, if I need to, but I think you need to look at what the criteria already is that is established for whether or not the commission should actually grant leave to discuss this case or not, and that is already included. So that would just be my point. I agree with you that it shouldn't replace the appeal system. But I believe that's already in the bill, and that is one of the grounds. And all this does is say whether you appealed it to the Court of Appeal is the same as if you appealed it to the Supreme Court. You didn't exhaust your appeals, the Commission can still look at it. But it's not meant to replace, and I think the bill is drafted, is not meant to replace the current appeal system.
Mr. Caputo?
Well, if this isn't meant to replace the current appeal system, then I think we should say that, because I think on reading of this, one could certainly make the argument that it is, because as I said earlier, somebody who's convicted on May 1st can avail themselves to this stream of legislation on May 2nd, and to me that is unpalatable. And then, frankly, that is not the point of this legislation, period. So I hadn't, as I was just actually thinking about this as I grabbed a coffee, but if Mr. Housefather wants to rebut, go ahead.
Yeah.
Hold your thoughts. I will get back to you. Monsieur Fortin.
Merci, Madame la Présidente.
Thank you, Madam Chair. Listen, Lib 1 seems laudable to me, and I agree with Mr. Garrison that we have to make sure not to deprive somebody of recourse that's legitimate if they don't have the means to go to appeal to the Supreme Court or the Court of Appeal. But the comments of my colleagues Caputo and Moore, that's something I hadn't considered before, but we should maybe find a way. That's not something that we want. Unless Mr. Housefather can explain that this is not the case, I think that, without us realizing, we might be inserting something to allow someone who either could go to appeal or to appeal for a judicial error or wrong. So, and I think that's not the objective. So I don't know if Mr. Housefather has something to propose, but without necessarily saying that you have to have gone to the Court of Appeal or Supreme Court, but we have to find a way to make sure that people don't have that option. The Court of Appeal is there to review lower level court decisions. So, and we have to do that job. Thank you. I completely agree with you, Mr. Fortin, but I think that's already in the bill. And that's why I said to Mr. Makuto, I agree with him. But you can't go to the Commission the day after you get convicted. If you look at Section 4, the exceptions in the bill.
Out so that everybody has it. Despite paragraph 3B, the Commission may decide that the application is admissible, even if the finding or verdict, now it says, was not appealed to the Supreme Court of Canada, and then it would say it was not appealed to the Court of Appeal or the Supreme Court of Canada. In making the decision, the Commission must take into account, A, the amount of time that has passed since the final judgment of the trial court. So basically, the day after would not. I mean, nobody's going to say, "Oh, well, it just happened yesterday. Now we should take it. It should be you should appeal." Then the reasons why the finding or verdict was not appealed. Then whether it would serve a useful purpose for an application to be made for an extension of the period within which a notice of appeal or a notice of application for leave to appeal may be served and filed. So basically, to me, this already says that the intention is you should have exhausted your appeals right if you could still do so, and it really would only be in the matter where the appeal is no longer permissible that they would even look at this, because they would generally say go back and appeal. So anyways, I think it's taken care of. I think it's a different issue, the issue Mr. Moore raised as to what the threshold should be overall. But I think the question of whether or not you should be allowed to hear a case, let's say that happened 15 years ago and there's no appeals rights, I don't think it should matter whether you appeal to the Court of Appeal or the Supreme Court if you believe that whatever standard the law has met has been made. Anyways, that's my feeling. Thank you.
Mr. Moore? sorry. Mr. Maloney.
No, I'm okay. The point's been made. Thanks.
Okay, thank you. Mr. Caputo.
Just briefly, in response to Mr. Housefather's statement, I understand his line of reasoning, and it does say right there, but it actually still permits the application to be admitted. That's my point. Is that a person notwithstanding it, it says they have to take it, the commission must take it into account. Doesn't mean that the commission must dismiss it. And let's face it, we've all been here long enough. We've generally are all called to the bar here, as far as I know. Or Mr. Garrison, I believe, is very learned. Oh, sorry, she's called to a different
Higher calling.
Yes, a different professional credential, equally as noble. But my point is that we've all seen laws, and Mr. Mendocino as minister, where we've said one thing and we've seen it interpreted, and that's why sometimes we have to work, in my view, with the utmost clarity, because it still says the application can be accepted. And do we even want to flood the commission with applications that they have to dismiss? That's a really important point in my view, because someone could say, hey, I can still apply. They still have to go through the process. I think we should make it very clear what our intent is here. If it is something that is historical, or even 5 years, even put a 5-year threshold on. We're catching a lot of convictions there. Put something in there that says, you know what, you didn't exhaust your appeal. You're not applying unless a certain amount of time has gone by. And I'm prepared to move that sub-amendment. I want to hear the rest of the interventions, because I think it's an eminently reasonable sub-amendment in the circumstances.
Monsieur Fortin.
Merci, Madame la Présidente.
Madam Chair, maybe in 4A, instead of saying that the amount of time that has passed, we could say that once the appeal time has delayed or has expired. So once the appeal right has expired, then the commission could look at the question. But if the right or if the delay has not expired, then the commission could not look at the question. Could we do that?
Je pense que
I think that your question is for the committee, for us to think of. Well, it's a suggestion, but Mr. Caputo said that he talks about a sub-amendment. But, my thoughts following our discussion is that we could possibly agree to avoid the trap of somebody asking for a review after a decision, so that we could say that that appeal time has to be, the expiry has to have passed. So to look at the expiry of the appeal rate. And the objective is that if somebody that's convicted decides at that point to appeal, and then but if he decides not to appeal, then he could go to the commission, but he couldn't go back to do an appeal the week after. But that could be a compromise, I think. And maybe that's a question for Ms. Decker or a suggestion for the comment committee. Well, if you want, Ms. Decker could respond. Is this a question for Ms. Decker? Just a suggestion, but yes, I would like to hear what she has to say, yes. Madam Chair. I would like to let my colleague Ms. Desner respond. Okay, one moment, please.
We'll have to make the sound test. I'm sorry to interrupt the business here and check with the interpreters. Thank you. Can you say a few words for us, Madame Bessner, please?
Yes, certainly. Please let me know if I'm being received in the translation booth and in the room.
It's all good, thank you.
Okay, wonderful.
C'était fait. On recommence alors. All right, let's start again. So, good morning, Ms. Messner. Thank you for being here to help us. Now, I don't know if you heard the question from Mr. Fortin. Now, if I understood the question, it was whether it would be possible to include in the bill the idea that the Commission would consider the time that has passed since the person did not appeal, and that the person did not appeal his conviction. So that's something that we could consider, yes, if the committee wanted us to. And maybe the place to do that would be in paragraph 4A. At the end, we could say that the time that has passed since, I'm going to go into English here, because that's how I had thought about it.
Time within which the amount of time that has passed since the time within which to file an appeal has expired. So just a different formulation to get at that point might be possible.
Merci beaucoup, Madame Bessner.
Thank you, Ms. Bessner. Mr. Fortin, is that sufficient for you? Well, what I understand is that we would consider the time spent since the expiry of the appeal date, but do we make that a condition that the appeal date has expired, or the right to appeal has expired? I think that's the concern of the committee. In my view, I might be wrong. Well, if it would be a factor to be considered if we include it in this paragraph. So the commission, when they had to make that would be a factor to consider when to make a decision. And I might add this, that factors that are included in the exception are from the relevant jurisprudence in this field. And now, an explanation that the court had given was in MacArthur, from the Superior Court of Ontario, and then that was appealed to the Superior Court of Ontario, and then the Supreme Court did not hear the appeal later. But the court had said that sometimes there are cases that require a review. So the court, and I'll just quote this in English.
Considering whether an accused has exhausted his or her rights of appeal or judicial review, a flexible approach must be taken, albeit one that is consistent with the intention of Parliament. Puis, un instant là, c'est que j'ai pas de lunettes pour.
Sorry, I don't have my glasses.
Les tribunaux ne sont pas là pour mener.
Basically, courts are not there to conduct reviews. They're there to deal with questions of law. So the right thing to do in this case would be an appeal. But if there's a need to go and get new evidence that's relevant on the question of wrongful conviction, that's where the court has said that that's the role of the Minister of Justice and then possibly the future commission to conduct an investigation, to go and get that new evidence and to consider it within the context of the entire case. So I wanted to add that. It's relevant here if someone has not exhausted their first appeal. Thank you, Ms. Bessner. And I'm happy to see that I'm not the only one that has to take their glasses off.
Monsieur Fortin, merci beaucoup.
Thank you, Mr. Fortin, and thank you, Ms.
Bear with me. I have Monsieur Moore now.
Look, I'm certainly sympathetic to the objective that Mr. Housefather has, and perhaps, my decision would be different if we were dealing with our amendment first and his amendment second. But we have to look to the remedy section of this legislation. This involves in many cases, will involve a new trial, or it will involve the Court of Appeal hearing an appeal that it hadn't otherwise. So the Commission doesn't decide whether someone's guilty or innocent. It restarts the process or continues the judicial process. I have to go back to the evidence we've heard around victims and victims' families being re-victimized by the process. And that's why taking a situation that I feel on the passage of this legislation, we are going to end up with a flood of applications. So it makes abundant sense to me to not require someone have availed themselves of an appeal to the Supreme Court of Canada before availing themselves of the wrongful conviction process. That makes sense. My concern is that Mr. Housefather's amendment is going to further open up what will be a floodgate and will be a very painful time for victims of crime and their family. And I'll just quickly make the point. When the decision from the Supreme Court found unconstitutional the consecutive sentencing requirement for those convicted of first-degree murder, that if they had convicted multiple murders, that they would have consecutive periods of parole ineligibility. We heard testimony at this committee from victims' families that said, we thought the process was over. This is horrifying for us. We had begun to heal, and now there's a scab that's been ripped off. Or we heard from Tim Bosma's widow that she said the one good thing about that came out of this was knowing that my daughter would never have to face the accused or the convicted, would never have to face him at a parole hearing. Now with that decision, her daughter will have to face her father's killer at a parole hearing. So I hope you can understand my concern of flooding our already overstressed justice system with potentially frivolous cases that are who amongst the convicted wouldn't want a second shot? Everyone would. Everyone would want it. So then we turn to the legislation to say, how do we prevent frivolous applications? What are we as parliamentarians telling the Commission to look at? And if we look at the current law, it's the Minister of Justice has to feel a miscarriage likely occurred. If we look at the UK, they have to feel there's a real possibility of a miscarriage of justice. If we look at North Carolina, they have an even higher threshold, so it's not of factual innocence. So it's not fair to compare their non-requirement to appeal to ours, because our thresholds are so dramatically different whereby someone can avail themselves of this process. So it's for those reasons. Mr. Fortin's suggestion, I think, is a good one. I think it would make and I would support it. It would make what could be a bad situation a little better. However, overall, on Mr. Housefather's amendment, I still can't support it because of how I feel flawed the system as a whole is unless we amend our threshold.
Madame Gladue.
Thank you, Chair, and thank you to the committee. I'm very happy to be here. Obviously, not with the same depth of legal experience as many of you, but what I have seen at my office is numerous inquiries where people do not like the judge's decision, and they are militant about wanting to pursue every avenue where they could possibly get this overturned. And so I share the concern of Mr. Moore that this may open it up to a flood of applicants. And so how do we make sure that there's enough criteria in place that you're not getting these frivolous complaints? So I think the amendment that Mr. Fortin has recommended is better, but it might be an idea to park this clause and talk about the CPC amendment and see whether or not then we can come back to this one and agree.
Madame Brière.
Merci, Madame.
Thank you, Madam Chair. I was interested to hear our witness on the amendment in general.
Mr. Mendicino.
First of all, I would like to say that I appreciated Mr. Fortin's comments. But I agree that I agree with Ms. Besner's interpretation. I think the goal of the government and also there's a clause here, Madam Chair, that says if an appeal has not been made to the Court of Appeal or the Supreme Court, and there's another clause that says if the Commission rejects the case in the following cases. So A, the Court of Appeal has not rendered a final judgment on appeal of the finding or verdict. So we're at 3A. And B, an appeal of the finding or verdict lies to the Supreme Court of Canada on a question of law. So I think it's a good response. It's a good clarification of the point that was brought up by Mr. Fortin.
The comments that have been made by my colleagues, Mr. Moore, Ms. Gladue, welcome to the committee, and others from the Conservative benches. I would just simply say this. I think we all share the concerns that families and victims who have been traumatized by a trial and who may be traumatized indeed by an accused who exhausts their rights of appeal need to be at the forefront of our concerns. And no one diminishes that, especially those of us who have grieved with those families in various tragic cases. And certainly I keep that top of mind as I think about this law. On the other hand, I would hope that my Conservative colleagues would recall that for many years, the individuals who were the inspiration for this bill were themselves victims of miscarriages of justice, and I think that is precisely the point that Mr. Garrison was making. So in our effort to ensure that those miscarriages are corrected, we have put forward a piece of legislation that sets a standard that I think does not aim to open the floodgates, as has been characterized, but rather set the bar in a way that allows those who have exhausted their appeals or who choose not to appeal to come before this commission to ensure that those wrongs are righted. And so for that reason, I do support my colleague, Mr. Housefather, in Lib 1, and I would urge all colleagues to vote in support of it.
Thank you very much. I'm going to return back to Madame Brière. Je m'excuse.
I'm sorry, but I think you had a question for Ms. Besner, and
you could ask again, maybe. Merci beaucoup.
Merci, Madame la Présidente. Je demandais.
I was asking for the general opinion from of our witnesses on the amendment. Thank you.
Madame Besner or Madame Field would like to start off first.
Je crois avoir mentionné.
I think that I mentioned at a past meeting that Mr. Housefather had very well described the motion so I have nothing to correct. What he is saying as an exception, so claimants have to exhaust their right of appeal first, and that will stay the same. That will remain a requirement. But the modification or the amendment being proposed that exceptions can be studied if the commission studies or looks at the factors listed so if they look at factors that are in line with jurisprudence. And I want to add two more things. So first of all, whether there are, with regard to frivolous claims that are presented to the commission. So there are two other provisions in the law, or in the bill rather. that address this. So the Commission can use this measure if it's not in the interest of justice. So for example, if a claim is frivolous, so in Scotland, for example, they have that idea in their legislation, and they use that. So perhaps that's something that we could consider. Similarly, in the factors in the final decision, and that's a little bit further in the bill on page 6. So, and we have that in C40. So this cannot so it's in the current law that the fact that an application is not intended to serve as a further appeal and that the remedies set out in subsection 2 are extraordinary remedies. So that idea, so if there's something that new that comes up that puts in question the conviction, it's a safety valve. So the idea is not to re-examine all the evidence that was already decided upon by a previous court. So I wanted to add that, if that helps you in your debate.
Merci beaucoup, Madame.
Thank you very much.
Thank you very much, Madam Chair. While I appreciate the intent of Mr. Fortin's possible sub-amendment, I think we're getting into an area here where the bill, as originally drafted, already describes these as exceptions. And I think we're also hearing a kind of contradiction from my conservative colleagues who tell me that the justice system gets almost everything right, and I agree with them on that, but then suddenly we'll have a flood of wrongful appeals. I just don't see how those two things operate at the same time. But my concern is, with Mr. Fortin's possible sub-amendment, that we'll get into unintended consequences by adding that wording. So the bill as drafted allows the Commission to say, we are not looking at this case because your appeal period hasn't expired and you have every ability to appeal. That's certainly allowed by the wording of this as it stands. So I don't think there's any need for us to fetter the Commission by saying, absolutely, you can't do that. So it's already there. And we're already dealing with exceptional circumstances, as we just heard from our expert witness. So I, again, as Mr. Mendicino, would urge people to, yes, always keep in mind the victims of crime, but also we've had some very dramatic cases, and we have some very dramatic outstanding cases of families who are trying to make sure their loved ones are released from jail because they've been wrongfully convicted. And so that's exactly what this commission is designed for. And the current process that goes through the minister has been found by everyone involved, including the ministers who've dealt with it, to be too restrictive and also to be too subject to political timetables, I guess I would say. Rather than whims, it's timetables. Ministers are busy people. How many cases can they deal with? And so very few people have gotten through the existing system where there's clearly a miscarriage of justice. So I would hope that as Lib 1 is now drafted, that it does take into account those very few cases where the Commission will be given the ability to examine those applications. It does not require them to do so. And the Commission will very clearly establish within the legal community what those parameters are. And so I would urge us to not delay this further. Thank you.
Thank you, Mr. Garrison. I will now move to Mr. Housefather.
This is going to be very fast. I agree entirely with what Mr. Garrison and Mr. Mendicino said. I think the combination of what's in Section 4 and Section 5C makes very, very clear that the Commission is not going to frivolously entertain claims that should have been appealed. I think we have to, I believe in the good faith of the people on this Commission to make good and wise decisions. And so nobody can stop frivolous applications, but the Commission is not going to entertain frivolous applications. And I think I understand the Conservatives' perspective that there should be a different threshold, but I don't think this is what deals with that. This deals with who can make an application, and I really think that the sub-amendment being proposed wouldn't add anything of value and might indeed have bad consequences. So I would urge people to vote on the amendment as is, and if you like it, vote for it. If you don't like it, don't vote for it, and move on.
Thank you, Mr. Housefather. I will now ask, shall Liberal one carry? Recorded vote? I think somebody should be asking that, but that's what I'm hearing. So, Mr. Clerk, please go ahead.
Sure. Thank you, Madam Chair. On Amendment Lib 1, Mr. Maloney.
Yes.
Madame Brière.
Oui.
Mendicino.
Oui.
Monsieur Housefather.
Oui.
Madame Dillon.
Oui.
Mr. Moore.
No.
Madame Gladu.
No.
Mr. Caputo.
Nope.
Monsieur Van Popter.
No.
Monsieur Fortin.
Oui.
Mr. Garrison.
Yes.
E74. Not carried.
Thank you very much. Clause 3 is carried. I'm sorry, Lib 1. I'm being ambitious, and my hope is Lib 1 is carried. I now will ask CPC-1 if there's a member that would like to speak to that.
Believe it or not, Madam Chair, I'm not going to belabor the point on this because I've had the opportunity to speak to CPC-1 in the context of some of the other bills. I think it's important. Some mention has been made of other systems, and I just want to quickly talk about our own system. The current system deals with scenarios where the Minister of Justice evaluates applications and can move forward with remedies if he or she feels that a miscarriage of justice likely occurred. In the United Kingdom, which has had a commission for some time now, and as I mentioned, experienced a flood of applications once the commission opened its doors, they have the threshold of a real possibility that a wrongful conviction or miscarriage of justice occurred. In North Carolina, which we heard testimony, factual innocence plays a part in the application and remedy, and in this case, in this legislation, in Bill C-40, factual innocence is not required. So what is our threshold being proposed in Bill C-40 is that a miscarriage of justice or wrongful conviction may have occurred. And in my opinion, one, that threshold is too low, and two, it's a fact that it's lower than any other threshold in any jurisdiction, including our own, that we looked at. So CPC 1 would change our threshold in C-40 from at the investigative phase that a miscarriage of justice may have occurred to a real possibility that a miscarriage of justice has occurred. We're replicating a peer country, the United Kingdom standard phrasing of real possibility. So why do I suggest this? Because we want to have a system where a miscarriage of justice application would be exceptional. The process we have is strenuous. Though the accused can avail themselves of legal aid, they can avail themselves of all the charter rights to which they're afforded, and we heard over and over, and I've mentioned this before, but I look at everything we do at this committee through the lens of the victims that have appeared before our committee, and the victims and their families that have appeared at this committee have said that the judicial process itself re-victimizes them. They've said that one of them, I remember very clearly, said, "We do not have a justice system in Canada. We have a legal system." That's how she felt coming out at the other end of the process. So In light of what we've recently heard from outgoing former Minister Lametti about judicial vacancies, in light of what the Chief Justice of the Supreme Court has said about judicial vacancies, in light of the Jordan principles, in light of what all of us are hearing from our constituents about delays in the system, in light of the extreme stress that's put on victims and their families going through the process, the threshold whereby we say, you know, you're going to get another crack at the whole thing. You're going to get a new trial, or you're going to go to the Court of Appeal, has to be higher than a miscarriage of justice may have occurred. And that is why moving CPC 1 and feel that we should mirror the UK standard that a miscarriage of justice, that there's a real possibility that it occurred. Thank you.
Just a second, please. Mr. Van Popta.
Good. Thank you. I too speak in support of CPC motion number 1. We had a person from the UK Commission give testimony, and I thought that his testimony was very helpful to this committee. Mr. Curtis was his name, and when he was asked the question by one of my colleagues what the UK's threshold was for directing their commission to conduct a review and to refer the case back into the trial system, the Court of Appeal. This is what he said. I'm just going to quote a short little piece of his testimony. Our test is that there is a real possibility that the appeal courts would quash the conviction, and our case law tells us the real possibility is below the balance of probabilities, that it is less than a 50% chance in that respect. It has to be real. So it is reasonable rather than fanciful. And then he went on to say, we have some helpful case law and decisions that guide us on that. Now, Mr. Curtis didn't cite any specific case, but I did research and I came across their leading case, which is Pearson. Pearson was convicted of murdering her husband's new girlfriend. And she had gone through the whole appeal procedure, and then she applied to the commission. It was just a new commission in the United Kingdom at that time, so this is their first case. And the judicial review court had to decide what a real possibility meant, and this is what they said. I'm just going to quote from the Pearson case, and I think that this is really what their law is. The real possibility test prescribed in the 1995 Act as a threshold which the Commission must judge to be crossed before a conviction may be referred to the Court of Appeal is imprecise, but plainly denotes a contingency which in the Commission's judgment is more than an outside chance or a bare possibility, but which may be less than a probability or a likelihood or a racing certainty. The Commission must judge that there is at least a reasonable prospect of a conviction if referred not being upheld. The threshold test is carefully chosen. If the Commission were almost automatically to refer all but the most obviously threadbare cases, its function would be mechanical rather than judgmental, and the Court of Appeal would be burdened with a mass of hopeless appeals. If, on the other hand, the Commission were not to refer any cases unless it judged the applicant's prospect of success on appeal to be assured, the cases of some deserving applicants would not be referred to the court, and the beneficial object which the Commission was established to achieve would be, to that extent, defeated. And when I that's the end of the quote. When I listen to the members of this committee argue their points, I think that they agree with this. I think that that's exactly what we were trying to aim to do. And so then I think that's a very strong argument in favor of adopting the UK language. We will then have the advantage of 25 years of jurisprudence coming out of the UK. The Pearson case was only the first case, and many, many other cases refer to it, so it is still the leading case. So I would argue very strenuously in favor of adopting the UK language it captures exactly what I think that we are intending to do. Now, if on the other hand, this committee goes with the lower threshold, the question will be, what was Parliament's intent in doing that? I would certainly argue, if I were acting for a person who felt that they were wrongfully convicted, that Parliament's intent was to not adopt the UK standard, but to go to a lower standard. And that's what I'm concerned about. And I would point out, I would just wrap up with this. With the Milgard case, it was never the problem that the threshold was too low. The problem was the dysfunctionality of the review group. It was too political, right, as Mr. Garrison had pointed out. That's the problem. That is already being remedied without playing around with the threshold. Thank you.
Mr. Garrison?
Thank you very much, Madam Chair. With respect to my Conservative colleagues, I think they're missing a piece of this clause. It doesn't say that the standard is the miscarriage of justice may have occurred. It says the Commission has reasonable grounds to believe that a miscarriage of justice may have occurred. And I'm not actually certain that that's not a narrower standard than what the Conservatives are proposing here. So I don't think it's obvious that the language from Britain is narrower. Then I actually think it may be broader than what's actually already in this bill, because this requires the Commission to have reasonable grounds to believe, which is a well-established Canadian legal concept. We know in law what that means in Canada, and I think, and again, I'm with all due respect, I think that we may be misjudging the impact of adopting the British standard. It may, in fact, be broader than what's adopted in the bill. But I think the advantage of what's in the bill is it's very clear, and it comes from Canadian legal traditions where we know what reasonable grounds to believe actually means. And there's lots of Canadian jurisprudence on that point. So I would urge us to leave this wording as it is. And I think the intent of Parliament here, the reason we're dealing with this is because grounds have been too narrow. Yes, we are actually trying to open the door a bit farther to those who've suffered miscarriages of justice. So I don't think there's any question about what our intent is here. But I think there's some question about whether that British standard is actually a much broader standard than what's actually in the bill.
Thank you very much. Mr. Caputo?
Thank you, Madam Chair. I respectfully disagree with Mr. Garrison on this point. Reasonable grounds to believe as opposed to an actual belief, in my view, are two different concepts. One is an actual belief. One is you have a reason and a basis to believe. And in fact, I'll actually put that question to our experts, whether based, they probably have to look at the bill as a whole, but based on this clause, are we narrower than the UK standard, or are we broader than the UK standard? I'd like to hear their positions on that, please.
Mr. Housefather?
Oh no! Sorry, I'm not.
I'm sorry, you're asking a question for staff?
Yes, I may have an
certainly.
intervention after that.
Please, go ahead. You're asking,
either or.
Madam Besner, did you get that? Okay.
Yes, I did. Excuse me. Indeed, the language in the investigative threshold here really relies on what we find elsewhere in the criminal code. What we're talking about here is when can a condition invoke its investigative powers. So we do see this elsewhere in the criminal code, so it was definitely like an intentional choice. With respect to the UK, the real possibility standard figures in their referral powers back to the courts, and that's just how their criminal code is structured, about a real possibility that the Court of Appeal will not uphold the appeal. So, our statute here in Canada is different, and so definitely we incorporated the concepts that are, familiar in the criminal code. I just wanted to elaborate on another aspect of this provision. There's an or here. It's that there are reasonable grounds to believe that a miscarriage of justice may have occurred, or that it's in the interest of justice to conduct an investigation. So there's an alternative there that's being introduced because a lot has been heard in the past about the minister's powers to conduct an investigation in this context as already requiring that there has to be reasonable grounds to believe that a miscarriage of justice occurred, and yet there's no evidence to substantiate that. And there's been some case law that has pointed out the catch-22, if you will, that how can that even be determined unless there's some ability to seek out some relevant information to look into the matter to see if there's really merits in continuing on with a review. And so that's why the language is changing a little bit here to provide that alternative. And just also to point out that when it comes to the final referral back to the courts for a new trial or a new appeal, there it's a little bit higher. It's reasonable grounds to conclude, not believe, that a miscarriage of justice may have occurred and it is in the interest of justice to do so. So that too will get at not sending back to the courts frivolous matters or ones that don't have merit.
Thank you very much.
Okay, thank you. I think Ms. Besner answered my question in her last thought there about reasonable grounds to believe versus actual belief. It seems as though it is a more narrow concept, and I don't disagree with Mr. Garrison. I mean, the whole reason we're here is because people have told us that the current legislation is unduly restrictive. So the debate we're having right now is to what degree do we open it up? It's fairly plain. I don't know that we can simply say, well, they've said it's too restrictive, therefore let's open it up. We have to, as parliamentarians, our role is to question, well, how far do we open it up? At what threshold are we looking at? And I take Mr. Moore's comments as being opposite here when we're thinking about, the threshold has been too high, but does that mean that we make the thresholds what could be unduly low, where we're looking at a flood of applications even that are not themselves meritorious and were not the intent of the legislation, which is to say, look, too many people who were wrongfully convicted have not been able to avail themselves to the process, and that is a problem, and we want to remedy that. That doesn't mean that we want to avail the process unduly to people who are simply dissatisfied, and I worry that we are going too far. I know that this amendment is likely to be defeated, but I did want to place my concerns on the record. Thank you.
Thank you very much. Mr. Housefather?
Thank you very much. I just want to come back and echo what Mr. Garrison said again. When we change words that have an established concept in our criminal code, and have an established concept in Canadian law to words that have a foreign context and don't exist here, you have unintended consequences. And I would point out exactly the flaw in amending 695.1 as is being proposed in this amendment by Mr. Moore, and then noting further down in 696.2, you're coming back to if the commission has reasonable grounds to conclude that a miscarriage of justice may have occurred and considers it in the interest of justice to do so, it must under the remedy section, and there's no amendment proposed to change that. So essentially, we're not going through the whole bill. We're changing sporadically things in one place that are mentioned in other ways in other places, and in the end, we would have a bill that doesn't work together. If in the end you're changing the concept once, you have to change it throughout the entire bill, and there's multiple places in the bill, then it would have to be changed again. So anyways, I just want to consider, here, I think the drafters use an established concept in Canadian law, and I'm not really entirely sure whether it's less or more restrictive either, because I have absolutely no idea in Canadian law what a real possibility means. Thanks.
Monsieur Fortin?
Merci, Madame la Présidente.
Thank you, Madam Chair. Ms. Besner's answer is convincing to me. I have to admit, had I heard her, I maybe not have made that sub-amendment, or I may not have raised my hand. But I understand the argument that a real possibility can be interpreted, and how should I say this, as less restrictive as reasonable grounds. I agree, but I don't agree with Mr. Housefather and Mr. Garrison, respectfully. I think the phrase reasonable grounds is good. But what Ms. Bessner is saying is interesting. So she's saying at the point where we're trying to decide whether we hear the appeal or not, so the idea that the miscarriage may have occurred or that it serves the interest before even looking at the case. That doesn't mean that we'll order a new trial. Because 695.6 talks about reasonable grounds to conclude. It's heavier. It's a higher threshold than reasonable grounds to believe. And we're talking about and instead of or. So the objectives of CPC 1 appears to be satisfied in 696.62. But so we'll be hearing more cases of wrongful conviction. So I will be voting against CPC 1. Thank you, Mr. Fortin.
Briefly, I agree entirely with Mr. Garrison's intervention. I also echo Mr. Housefather's point about introducing new legal standards that are unknown to Canadian jurisprudence, and rather suggest that we stick with the threshold that is proposed by this bill. And if anything, I would just add one more reflection, and that is rather than be preoccupied with the phrase reasonable grounds versus real possibility, as my Conservative colleagues have proposed that we adopt from the United Kingdom, the real operative change that is being proposed in this bill is going from reasonable grounds to believe that something was likely to may have. So going from likely to may have is the material change. And that is a very conscious, deliberate intent on the part of the government to create a less stringent standard, precisely because of the concerns that have been expressed by the current Minister of Justice and Attorney General and his predecessor, and by the community of the victims of miscarriages of justice, who suggest that the new standard that is being proposed is one that will ensure that this issue is properly addressed. And for that reason, I intend to vote against CPC 1.
Madame Gladue.
Thank you, Chair. Obviously, I'm late to the party on this one, but what I would say is we're trying to change the system to get a better outcome. And I'm not sure then why we wouldn't take the learnings of 25 years from the UK of jurisprudence there that they seem to be quite satisfied that works. So that's why I would support CPC 1.
Shall CPC 1 carry? Yes. Recorded vote. Monsieur Le Greffier.
Merci. Merci, Madame la Présidente. Le vote sur CPC 1. Monsieur Maloney?
No.
Madame Brière?
No.
Monsieur Mendicino?
No.
Monsieur Housefather?
No.
Madame Dillon?
No.
Mr. Moore?
Oui.
Madame Gladue?
Oui.
Mr. Caputo?
Yes.
Mr. Van Popta?
Oui.
Mr. Fortin?
No.
Mr. Garrison?
No.
It's 47 defeated.
CPC 1 is defeated. Shall Clause 3 carry? As amended.
No.
I hear more yeses on division. Monsieur Le Greffier, s'il vous plaît. Oh, on division. Okay, très bien. So Clause 3 as amended is carried. We're going to take 2-minute break, please. call us back, and we hope to continue and finish this bill before the next 25 minutes. We're at Clause 4, NDP-2. Mr. Garrison, would you like to move it?
Thank you, Madam Chair. Yes. I would like to move NDP2. What we're trying to do here is not create new powers for the Commission with this amendment, but to take advantage of the expertise that the Commission will inevitably acquire by doing its work. And to allow, this amendment would allow the Commission to make recommendations to address any systemic issues that they see arising in the cases that they look at. And who, of course, would be better placed in our legal system than this Commission to identify those systemic problems. The government certainly has made a commitment, and the NDP has made a commitment to try and address systemic racism and the systemic discrimination against Indigenous people in our legal system. And so it would seem to me to be foolish to pass up the opportunity to get the advice from this Commission. But I want to stress again, it's not creating a power. The Commission is not allowed to do anything new here other than to offer the benefit of its experience to the rest of the legal system and to Parliament in the future. And so that's my reason for moving this motion. I think it was something that probably should have been there from the beginning and maybe was inadvertently overlooked, because certainly the whole process we're going through here is to trying to address and prevent future miscarriages of justice, not just to correct those individual cases. Thank you.
Is there any discussion, Mr. Fortin?
Merci, Madame la Présidente.
Thank you, Madam Chair. I understand the objective of NDP-2, and I think it's a laudable objective. However, respectfully, I don't agree with my colleague. There's already the Law Commission that has that mandate, and we would be adding another mission. So not only would it object to respond to wrongful dismissals or convictions rather, but it would also be working towards improving the legal system rather than making the process more efficient. We'd be making it more cumbersome. So the way that it's drafted, well, it could be easily interpreted that the Commission has an obligation to make recommendations. But whereas the Commission will not necessarily have to make recommendations in every case. But if we were to adopt this change, I think we'd have to add that, if it deems it useful, but not to say that its mandate is to make recommendations. So it seems to me that this is where we're adding a mandate to the Commission, and respectfully, I think it would be inappropriate. Thank you.
Shall NDP 2 carry?
So vote on NDP 2. Mr. Maloney?
Yes.
No, on division. On division.
Recorded vote? Was it recorded?
That's fine, on division.
Okay, on division.
It's carried. BQ-1. BQ. No.
Madame la Présidente.
Thank you, Madam Chair. So BQ-1 aims to create a gap in the bill that provides for certain requirements for people who will be appointed to this commission. But one of those requirements should be that each commissioner has to have the ability to speak and understand both official languages. And that had been brought up by the Barreau du Québec, and I think it's an important argument that we have to take into account. So we're proposing then, or so that we're proposing that it be added to the bill. And I think the amendment speaks for itself. Thank you.
Thank you very much, Madam Chair, and I certainly appreciate the dedication the Bloc always shows to protecting language rights in both official languages, and I certainly share that concern. However, I think there's an unintended consequence when we're dealing with the Miscarriage of Justice Commission, and the draft legislation we have before us says that the Commission has to, or the appointment of commissioners should take into account diversity and to take into account those who are under or overrepresented in the justice system. And by doing so, I think Mr. Fortin's amendment inadvertently excludes, for instance, unilingual francophones, or in the case of Quebec, when we have many Indigenous nations which speak French and, for instance, Cree, would be excluded from serving on this commission. So I think there's an unintended consequence by applying a very narrow requirement of being able to function in both official languages in this case. And I would hate to see Indigenous lawyers who, as my example is Cree and French speaking, not being able to serve on such a commission. The commission elsewhere in the bill requires bilingual services. It requires translation services. So this will be a commission that functions in both official languages. But when we're appointing 9 commissioners, some of them full-time and some of them part-time, I think that this narrows the field too much. And certainly, if I also apply it to British Columbia, there are very few Indigenous lawyers to start with, and there are very few who are fluent in French, English, and their Indigenous language. There are many who are fluent in their Indigenous language and English. And in Quebec, many who are fluent in Indigenous language and French. So I think with respect, Mr. Fortin's amendment in this particular case creates an unintended consequence, and therefore I will vote against it.
Mr. Fortin?
Thank you, Madam Chair. I thank my colleague for his remarks. I would say that I agree with him that a lot of parties and lawyers who speak only French or only English, or they might speak English or Cree or another language, another Indigenous language, that's correct. But here we're talking about designating commissioners who will play almost a quasi-judicial role. And I think if we want all these people that Mr. Garrison is referring to, lawyers or other parties, whether they're unilingual, multilingual, but who don't necessarily speak both official languages, if we want everybody to have access to a fair system, we have to at least require that the commissioners be able to operate in both official languages. So could a commissioner speak free in addition to English and French? Perfect. It would be great. English, Italian, inaudible comment. Italian, Portuguese. I love Italian. You know that, Mr. Mendicino, but even if I don't speak it, I love the language. But what I'm saying is, and in Canada, we have 2 official languages. And I think when we have 2 official languages, there can be hundreds of other languages spoken in language in Canada, and we have to respect them. But there are 2 official languages, and I think that our tribunals, or quasi-judicial bodies, necessarily have to reflect that principle of linguistic duality. So respectfully, in response to Mr. Garrison's argument, I think we have to ensure that both official languages are spoken by the commissioners.
I'm going to suspend for 60 seconds. back in order. Thank you so much. The committee normally will conclude at 10:15, but if need be, we can go 10 minutes extra, just to let you know. But we hope we don't need to, but in case we do. So I am going to ask for, I'm not sure who was the last, who was speaking, or we were at BQ-1. Was there any other speakers, or is there a vote? Okay, we will take the vote. Shall BQ-1 carry?
No.
Do you want a recorded vote? Recorded vote, please.
Très bien. Merci, Madame la Présidente. Sur BQ1, l'amendement BQ1, Mr. Maloney?
No.
Madame Brière?
Oui.
Monsieur Mendicino?
Oui.
Monsieur Hausfather?
Oui.
Madame Dillon?
Oui.
Mr. Moore?
No.
Mr. Brock? Sorry.
No. The Brock Star.
It was,
no.
it was to happen once. I'm sorry about that. Madame Gladu?
No.
Mr. Caputo?
No.
Mr. Van Popta?
No.
Mr. Fortin?
Oui.
Mr. Garrison? Can I please go back to Mr. Maloney? I misheard your vote.
No.
No? Okay. Very good. So, nay 6, yea 5. Defeated. It's defeated.
Motion is defeated.
Comptez 6 contre.
There were 6 against. I counted 5 Conservatives and Mr. Maloney, rather, and Mr. Garrison. Okay, I'd forgotten about you. So we're abandoning bilingualism in Canada. Sorry.
NDP-3, can I ask the member?
Thank you, Madam Chair. I'd like to move the motion. I just want to say briefly, it was the Canadian Association of Elizabeth Fry Societies who really brought to our attention a dilemma that's created for those who believe they're wrongfully convicted, because in order to avail yourself of services in the Canadian correctional system, you have to take responsibility for your actions, as it's called. So those who continue to say I'm innocent are often denied privileges and programming within the correctional system. So all of this intends to do is for the Commission to advise or notify or allow the Corrections Canada to know that their case is being seriously considered, and the hope that this would not cause people to suffer additional penalties while they're waiting for an adjudication of their application. I know that there has been an amendment suggested, and I'm completely supportive of the amendment. I think it's better wording, perhaps, than my original. So I hope to see us deal with this expeditiously. Thanks.
Mr. Maloney, I will go to you. You've submitted a sub-amendment to NDP-3. And so, yes?
Thanks, Madam Chair. I believe the sub-amendment's been circulated in both languages.
Yes.
So I won't take the time to read it, and as Mr. Garrison has already indicated, he's supportive of the sub-amendment. So I'll just leave it there. Thank you, Chair.
Okay, thank you to both of you. I am going to ask if the sub-amendment to NDP-3 carries. Okay, I hear, so it's carried on division. Shall NDP-3 carry as amended? Oh.
C'est allé un peu vite. Je voudrais.
We went through this a bit quickly. I agree with the sub-amendment, but I'm against NDP-3.
Still, the sub-amendment is carried on division. I will go back and ask, shall NDP-3 carry as amended? I need to ask. I'm sorry. I'm not hearing people speak. Can you take the call? Can you please? I'm not hearing.
Recording? Okay. Okay, very good. On NDP-3 as amended, Mr. Maloney?
Yes.
Madame Brière?
Oui.
Monsieur Mendicino?
Yes.
Monsieur Householder?
Yes.
Madame Dillon?
Oui.
Mr. Moore?
No.
Madame Gladu?
No.
Mr. Caputo?
No.
Mr. Van Popta?
No.
Mr. Fortin?
No.
Mr. Garrison?
Yes.
Yea, 6, nay 5.
Okay, carried. Shall Clause 4 carry as amended? Clause 4 is carried. On division. There's no amendments to clauses 5 to 20. I will group them together with unanimous consent for the vote. Yes. Thank you very much. Shall clauses 5 to 20 carry? They are carried on division. Thank you very much. Why on division?
Oh, no? Okay.
I heard the Conservatives say on division. So thank you, Monsieur Fortin. Shall the short title carry? Yes. Okay, short titles carry. Thank you. Shall the title carry? The title is carried. Thank you. Shall the bill as amended carry? Yes. Carried on division. Shall the chair report the bill as amended to the House? Yes. Yes. Thank you very much. Shall the committee order a reprint of the bill as amended for the use of the House at report stage? Yes. Yes. Thank you very much, everyone. That concludes our meeting for today. It's exactly 10 o'clock. Thank you very much for all your cooperation. Just before you leave, our next meeting is Monday. Can you give me a minute? Can we? Meeting is adjourned. Thank you very much. Can I just call the